Licensee responsibility for conduct of employees. Licensees are responsible for the conduct of employees and may be held responsible if their employees violate liquor laws on the licensed premises. Licensees may be held accountable for the criminal acts of employees, even if the licensee instructed the employee not to engage in the criminal activity or was not aware of the criminal conduct. To avoid the risk of a violation on their records, licensees must make a serious effort to be aware of what is happening at their place of business. Licensees must take necessary steps to prevent criminal activity by employees. They must also take immediate corrective action when they suspect criminal activity. To further minimize risk, for licensees who aren't ordinarily on the premises, these licensees should make occasional visits to personally observe activities of both employees and customers. It's probably a good idea to visit during all shifts and sometimes after hours. Licensees and permittees must prepare to act when they see red flags or indicators that some sort of criminal activity may be occurring at the business. A red flag could be a variety of things, such as syringes found in the building or parking lot, frequent trips by certain individuals to the restroom or parking lot, etc. A licensee or permittee may be subject to fines or suspensions if they know of criminal activities by coworkers and fail to take steps to deter or to report it. If a licensee or permittee suspects a problem and requests police assistance, the OLCC is less likely to hold them responsible or impose a severe sanction. Asking for police assistance, however, does not excuse licensees from the responsibility to personally monitor their businesses. Licensees should institute management practices and house policies to help avoid such problems. Unlawful activity. Just as licensees and permittees must take action when they suspect a coworker is involved in any criminal activity, they are also responsible for the actions of their customers. Licensees and permittees must not permit any unlawful activity on the licensed premises or in areas outside the premises that the licensee controls, including the parking lot. Unlawful or illegal activities include prostitution, public indecency, illegal gambling, or illegal drug use or sales in or near the establishment. In order to host legal gambling activities in their place of business, licensees must be sure the type of gambling they're considering falls into the lawful category. To determine which gambling activities are legal in their community, licensees should call their local district attorney. Orderly premises and neighborhood livability. Licensees and permittees are responsible for customer behavior which affects the neighborhood's livability. No licensee or permittee will permit on or in the immediate vicinity of the licensed premises noisy or disorderly activities. Noisy activities are those that a reasonable person would conclude interfere with normal living or business activities. Violations of state or local noise pollution standards may be considered evidence of noisy activities. Disorderly activities are those that harass, threaten, or physically harm another person. This may include abusive language, fights, or threatening behavior. Licensees and permittees are responsible for alcohol disturbances in the immediate vicinity of the business if the disturbances are related to the sale or service of alcohol. Immediate vicinity usually goes beyond the parking lot and may be as much as 2 or more blocks away from the establishment in some cases. Disturbances are defined as serious and persistent problems caused by customers who are noisy, disorderly, or involved in illegal activities. Examples: excessive noise, public drunkenness, unlawful drug sales, trespassing on private property, fights, alcohol or related litter, public urination. If an establishment has a history of serious and persistent patron-related problems, the licensee will receive a fine or other sanctions. Remember, the majority of licensees and customers do not cause problems for neighbors. Some licensees have occasional problems. Most often, prompt attention and cooperative efforts with the OLCC can help prevent continuing disturbances or resolve problems to the mutual satisfaction of those involved. Certified security. Oregon law requires that individuals who function primarily as security personnel must be certified by the Oregon Department of Public Safety Standards and Training, the DPSST. A person may be subject to this requirement if their primary responsibility includes any one or combination of the following duties: observing and reporting unlawful activity, preventing theft or misappropriation of items of value, protecting individuals and property from harm or misappropriation, controlling access to a premises being protected. This included checking ID at the door, detaining or placing persons under arrest, or providing canine services to guard a premises or to detect unlawful substance or devices. OLCC inspectors, police, and other law enforcement officers, when they visit licensed premises, may issue citations to both the licensee and the employee for failure to have the necessary certification. The fines range from $500 per employee to $1,650 per license. Also, you can contact the DPSST at 503-378-2100 or at the web address on the screen.